really didn't. You really think I did that? I didn't mean to hurt him.
Dylan Shoemaker walked into a state Supreme courtroom pleading his case, telling his victim's mother and the court he's remorseful for what he did. Shoemaker was sentenced Friday for beating 23-month-old Austin Smith last March. Before the sentence was handed down, Shoemaker and his defense attorney fought for the minimum sentence, 15 years to life.
I can't take back what was done. I wish I could. I would give my life for Austin. I loved him a lot.
Austin Smith was completely defenseless. That's a given. But there were other dynamics at work there, including my client's inability to either control his anger or frustration and his inexperience in babysitting.
Based on his short life now, what is to say he won't do this again?
Well, we don't know that. I think it's completely unlikely. It was a situational, circumstantial thing.
In Judge M. William Bowler's last words to Shoemaker, he told the now 17-year-old that in his short life, he's caused so much despair to so many people. Bowler said he listened intently to Shoemaker's testimony during trial and called him a manipulator who minimizes his actions.
The record will show that you admitted on July 23, 2013, in a phone call to your mother from the holding center, you stated, and I got a quote from the court reporter, "I am a 16-year-old blonde. Probably all I have to do is cry in front of the jury, and they're going to feel sorry for me," end quote.
Afterwards, Shoemaker was sentenced to 25 years to life behind bars.
We're asked to represent the defendant for the purposes of these proceedings, and he is charged with the following. On or about June 10th, 2017, in the city of North Royalton, George Brinkman Jr. did by force, threat, or deception restrain the liberty of the other person to terrorize or inflict serious physical harm on the victim or another. To wit, George Brinkman Jr. did by force restrain the liberty of victim Suzanne Taylor at her residence to cause the death of Suzanne Taylor by slitting her throat with a knife. This occurred at her residence on 11489 Ridge Road, located in the city of North Royalton, state of Ohio, Cuyahoga County. As charged as kidnapping, that's a felony of the first degree. You also have a count of aggravated murder. That charges that on or about June 10th, city of North Royalton, George Brinkman Jr. did purposely and with prior calculation to design cause the death of another. To wit, George Brinkman Jr. purposely with prior calculation to design did cause the death of Suzanne Taylor by slitting her throat with a knife. This occurred at her residence, same residence on Ridge Road, located in North Royalton, Cuyahoga County, Ohio. As charged, that's aggravated murder. You're also charged with tampering with evidence, same date, location the defendant did, knowing that an investigation is about to be or likely to be instituted.
21-year-old Brandon Spencer of Englewood bangs his head as a judge sentences him to 40 years to life after he was convicted of shooting a rival gang member at a 2012 Halloween party on the USC campus. The violence just 6 months after 2 Chinese students were murdered in an apparent robbery just off campus. Since then, USC security has been beefed up. Today, in LA Superior Court, Spencer begged for mercy from Judge Edmund Clark Jr. before sentencing.
I'm sorry for what happened, Your Honor, but I need to life in prison. And I'm not a bad person, but I made mistakes. But I'm not just some gangbanger that she tried to portray me as.
During sentencing, Spencer completely broke down.
The minimum period of parole eligibility is 15 years plus 25 years of life in accordance with Penal Code Section 12022.53D. This is to be concurrent with
the judge sentenced Smith Riley to life in prison without parole for Brooks' murder, and more time after that for shooting Martin, and still more time for using a gun. Smith Riley collapsed to the floor.
In the House Department of Corrections, mandatory consecutive underlying offenses. All those counts are consecutive each other. Over credit for time served, amount of 349 days.
The families say this was the first step toward healing.
I understand, what I did is a terrible thing, but I wasn't the only one in this situation.
For the first time ever, accused cop killer Ashford Thompson breaks down in the courtroom. With tears streaming down his face, he told the judge he's frustrated with the legal process.
I still don't have copies of the things that I've asked for. I don't have a copy of anything. I don't even know what the prosecutor's going to use against me.
Well, probably your statements, Mr. Thompson.
Thompson is accused of shooting to death Twinsburg police officer Josh McTarian in July 2008. Wednesday afternoon, McTarian's widow Holly sat in court as Thompson told a Summit County judge he's having a tough time in jail. He complained that he's not receiving his mail, that he's constantly being harassed.
How can these people just do anything they want? They don't even follow their command the right way. I've been harassed for I don't know how long. I'm trying to hold it in just to get this over with.
Thompson has been through a number of lawyers. His current attorney, Kerry O'Brien, told the judge he's planning on filing an additional 40 motions. The judge agreed to give him one more week to prepare. Faced with the death penalty, an exasperated Thompson told the judge he worried about getting a fair trial.
Your Honor, just execute me there because I can't get any kind of justice. I'm tired. I'm at the end of my rope. What can I do?
In Summit County,
25-year-old Michael Robertson wheeled himself into court, still recovering from injuries suffered in this wrong-way crash on 520. His SUV slammed head-on into Morgan Williams' sedan. State troopers found an empty bottle of whiskey in his front seat. For the first time today, Robertson was read the charge against him, vehicular homicide.
That you drove under the influence of alcohol and in a reckless manner and killed Morgan Williams.
Williams was on her way to work in Bellevue early last month. She usually takes the bus, but drove that day so she could visit a friend who's being treated for cancer. Today, Robertson wiped tears from his face.
We do waive for the formal reading, and at this point in time, we're going to enter a plea of not guilty.
Plea of not guilty is entered.
Bill Carlone, a lifelong friend of Morgan Williams, is still very angry about what happened, but he wanted to see Robertson in person.
He doesn't seem remorseful to me.
According to court records, Robertson was awaiting trial for a previous DUI filed last December when he caused the crash that killed Williams. If convicted, the 25-year-old would only go to prison for 6 to 8 years.
Friends and family gathered to remember a mother police say was killed by her own son. Deidre Jefferson, a beloved member of the Alief ISD School Board, was stabbed to death at her home on Friday. Just hours ago, a candlelight vigil was held in her honor, right there in the parking lot of the Alief Administration Building in the 4000 block of Cook Road.
Police say Deirdre's son, Blake Jefferson, brutally stabbed and killed his mom inside their Alief home early Thursday morning. Those close to them say something in his mind must have snapped. In court today, he broke down.
She's a very loving mom. I just saw both of them Tuesday night, and they were just loving and playful as always, and just chatty and talking. And, you know, I talked with her later that night, and there was no indication, none at all. I can't even begin to speculate.
The man sitting here today is not the one I once knew. He is not the one I fell in love with. He is a coward, and forgiveness is not an option for me.
After everyone had their chance to speak in this Wapello County courtroom, it was Dustin Armstrong's chance to say something about what he'd done.
Do you have anything you wish to say to me prior to my announcing what I'm going to do here today, sir?
No, Your Honor. Last April, police found 2-year-old Braden Young unconscious in his Ottumwa home with a broken jaw and extensive brain damage. Armstrong admitted in Monday's hearing that he grabbed Braden's jaw and slammed his head against a wall. Doctors told Braden's mother they thought he was going to die. Braden has made a remarkable recovery, but his mother says he will likely face challenges from the beating for his entire life.
Being betrayed by the man I was with for nearly 3 years brought me into the deepest pain I've ever known.
When Judge Joel Yates gave the guilty sentencing, Armstrong lost control of his emotions, dropped his head into his hands, and cried.
And you'll have plenty of time in the Iowa penal system to think about what you've done to this defenseless child.
Tears were shed throughout the courtroom, some of joy as justice was served, others of pain as Sue Adler watches her son leave for prison.
I remember this little bright, smiling, curly-headed kid that used to run to Mom and with open arms, letting kisses and hugs, you know. That's what I see when I look at Dustin. I don't see a monster.
This is in the District Court of Oklahoma County, State of Oklahoma, the State of Oklahoma versus Daniel K. Holtzclaw, case number CF 2014-5869. Verdict, count 1, sexual battery. We, the jury impaneled and sworn in the above entitled cause, do upon our oaths find as follows. Defendant is guilty of the crime of sexual battery and set punishment at 8 years. Count 2, procuring lewd exhibition. Not guilty of the crime of procuring lewd exhibition. Count 3, burglary in the first degree. Defendant is not guilty of the crime of burglary in the first degree, nor lesser included.
Yes.
Count 4, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 5, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 6, defendant is not guilty of the crime of stalking. Count 7, defendant is not guilty of the crime of sexual battery. Count 8, defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 20 years. Count 9, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 10, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 11, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 12, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 13, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 14, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 15, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 16, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 17, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 18, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 19, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 20, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 21, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 22, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 23, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 24, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 25, rape in the second degree by instrumentation. Defendant is not guilty of the crime of rape in the second degree. Count 26, indecent exposure. Defendant is not guilty of the crime of indecent exposure. Count 27, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 28, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 29, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 30, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 31, rape in the second degree by instrumentation. Defendant is guilty of the crime of rape in the second degree, and punishment is set at 12 years. Count 32, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 33, sexual battery. Defendant is guilty of the crime of sexual battery and punishment is set at 8 years. Count 34, sexual battery. Defendant is guilty of the crime of sexual battery and punishment is set at 8 years. Count 35, defendant procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 36, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Let me ask the jury, is this your verdict, so say you all? All right. Counsel, would you like to examine the verdict forms?
Not to say no. No, Your Honor.
All right. Mr. Holtzclaw, you and your attorneys just come forward.